Stanford University.
Yeah. Ready. Go. Perfectly on time. Welcome to EE 380, Winter Quarter 2011-2012, Year of the Dragon, I guess. What was last year? Year of the something else? Okay.
Rabbit.
Rabbit. Oh, the rabbit follows, the dragon follows the rabbit. Swallow the rabbit, okay. Pretty tough dragon, it's going after bunnies. I'm Andy Freeman, the other course organizer is Dennis Allison. Coursework is all online at EE380.stanford.edu in Administrivia. Everybody has various religious beliefs. One of mine is that technology is a way to fail, but it's not a way to succeed. I mean, no, I'm a realist. And one of the ways this plays out is legislation, which is sort of the ultimate in non-technology in some ways. Silicon Valley has, for some strange reason, traditionally ignored legislation with minor exceptions related to research. Give us a few $100 million a year and we're pretty much happy. This changed a bit about 10 years ago with a push to have a lot of government funding for green technology. However, Silicon Valley lives on IP, and IP is a creation of legislation. And other people who live on IP are political, and they care a whole lot about their interests, not ours. Thus, Silicon Valley discovered a few weeks ago that it doesn't take two to fight, that you can lose without even fighting at all. And over the past few weeks, Silicon Valley did fight in a sort of lame way. And it was sort of surprising to the other side that there was any fight at all, which may explain some modest amount of success. Today's speaker, Parker Higgins, is here to tell us about what happened, what's about to happen, and maybe even what should happen.
Exactly right. Should I put this on?
Yes. Yes, please.
All right. Hello. All right. So thank you, everybody. My name is Parker Higgins. I'm an activist at the Electronic Frontier Foundation, but I'll get to that in a second. I'm an activist at the that's my next slide. I will be around. I intend to have this be a little bit short so that there's time for questions. The Stop Online Piracy Act and the Protect IP Act have both gone through a lot of developments in a very short period of time. You know, things look totally different today than they did 1 week ago exactly. And so I know that people have a lot of questions. There's been some misinformation, and so I'll try to keep it relatively brief. So just a little bit about my background about the EFF. The EFF is a nonprofit law firm and digital civil rights group based in San Francisco. It's been around since 1991, which in internet years makes it pretty well established now. It fights for, I've got these all on the slides. We fight for digital civil liberties and users' rights, and that runs a whole gamut of things. Innovation and fair use and privacy and freedom of speech, and the list goes on. We try to be involved in almost all of these major cases, whether it's through actually representing one of the sides or filing a brief. And you know, if you're in this world, you'll see our name come up a lot. That said, we do focus mostly on litigation and not legislation. So when it's the case of something really extreme, like the Stop Online Piracy Act has been, we'll jump in there and help out our buddies in DC. But that's sort of an uncommon thing for us. So I've got a little bit of an insider-outsider perspective. Just a quick disclaimer that we have to do at the EFF when we go to talks. I am not a lawyer. I cannot give you legal advice, and you should not tell me the specifics of any case that you think you might have. That can only bring sorrow. If you do have a case that you want to bring to the attention of the Electronic Frontier Foundation, we've got a page on our site, but the upshot is you can email it to info@eff.org. it happens that you come to one of these and someone says, well, I've been downloading these files, and anyway, disclaimer over. So what are the Stop Online Piracy Act and the Protect IP Act? If you're like most people, this might have been the first you heard about it. When Wikipedia last Wednesday was one of thousands of sites to take their homepage black in some way. Wikipedia did it in a pretty extreme way. It wasn't obvious that you could use their site at all. Google blacked out their banner. It was a pretty unprecedented show of internet might. It was blacking out your logos, but still. So what was it about? The Stop Online Piracy Act and the Protect IP Act are bills that are currently under consideration of Congress and the Senate. The Stop Online Piracy Act was introduced by Lamar Smith of Texas, and that was just a couple of months ago. And before that was the Protect IP Act, which was introduced by Patrick Leahy earlier last year. And these bills are both descendants of an earlier bill called COICA, which is Combating Online Infringement, something or other. They got better with the abbreviations when they started calling them things like Protect IP than COICA, which I don't think rolls off anybody's tongue. Supporters say that these bills are about rogue legislation, rogue sites, that these are addressing piracy by taking on the problem of sites that are based out of the United States but aimed at the United States to deliver infringing material. So sites that a lot of the things that they were, it's a pretty broad spectrum that they've got here. It's things like sites that sell counterfeit clothes or bags to counterfeit pharmaceuticals. Of course, movies and music and those sorts of sites are implicated. But the point is that these are actions that maybe we do have law to address in the United States, but we can't address because they're based out of the United States, and so we don't have jurisdiction. So they serve into the United States, and there's nothing we can do about it. These bills are the latest in a really long series of wrong-headed policy around intellectual property. Going way back, you have the CDA, which addressed all sorts of things. It's the Communications Decency Act. I bring it up here mostly not because of its involvement in intellectual property, but because it sparked one of the first waves of internet activism. I'll get to that in a minute. More recently, we've got the DMCA, the Digital Millennium Copyright Act. That was passed in 1998, and that is the law that currently operates or controls how websites are to enforce copyright. And the important part of this, it's a very big bill, and there are two parts that are referred to most frequently. One is called Section 512, which has to do with what's called notice and takedown procedure. And so what this says is, and builds on the CDA, if you run a website that accepts user-generated content or any internet service, and you are not liable for what users upload as long as you comply with takedown notices. And so this established the way that sites like YouTube or Facebook or anything that takes uploads from users can get notified that what they're hosting is infringing and take it down and not be subject to a lawsuit. And that particular, there are a lot of problems with the DMCA, but that particular clause that allows safe harbor if you've got notice and takedown in place is actually the basis for a lot of the innovation that we've seen. Otherwise, you couldn't have a user-generated content site that operates with anywhere near the efficiency we've seen today. Just as a side note, I think yesterday YouTube put out a new ad campaign that they are now getting an hour of video content per second uploaded to YouTube. So you can imagine that if YouTube were liable for this content, it would take a lot of monitoring, a lot of billable hours for lawyers, especially because copyright is not something that you can tell is infringed by just looking at it. You need to be an expert, and sometimes you have the case where people are uploading major label or studio content, but they are that studio. Okay, so that's the DMCA. I'll talk a little bit more about it in a second. The Copyright Term Extension Act, which happened in 1998 also, that was one of the really bad laws. It's sometimes called the Mickey Mouse Protection Act, or the Sonny Bono Act, because he was one of the major supporters. And what that did was retroactively extend all active copyrights another 20 years. And given the economic justification for copyright, that it's designed to incentivize production, retroactively extending makes zero sense. There's no economist that would sit with that. And actually, in fact, this went up to the Supreme Court, and there were a series of Supreme Court cases related to these sorts of laws. And in Eldred, over a dozen Nobel Prize-winning economists wrote a brief and said, this doesn't make any sense. But it's a sort of wrong-headed IP policy that we've seen over and over again. Also, through the Supreme Court came the Grokster decision, which overturned an earlier or modified the 1984 Betamax decision and said that you could be held liable in contradiction to the DMCA, you could be held liable if you induce people to infringe copyright. So if you run a service and say, hey, you know what, we'll notice and take down, but it'll be fine, just upload it, then you can be held liable. And Golan also, last week was a big week. Golan came out, that's a Supreme Court decision that was announced last week that said that it was legal for Congress to take things that are in the public domain out of the public domain. So things that that may already be in use. Golan was a conductor who was using arrangements of public domain classical pieces, and then due to a law passed, and this one was in 1994, so before this whole timeline, he could no longer perform these without licenses. So a lot of bad decisions. This has been it's really a bleak history we've got here. And then, yeah?
The decision's bad or the laws? That led to the decision's bad.
So the laws are bad. There hasn't been a good copyright law in a long time. And I pointed out the CTA, which seems extreme, but actually 11 times in the 40 years preceding the CTA, copyright terms have been extended. The decisions also happen to be bad, and that's a function of who's on the court. And if you kind of never know how it's going to end up when it goes to the Supreme Court, because it's those 9 people. So it's a combination of the two.
I don't actually disagree with you, but can you clarify what you mean by bad?
Okay, I can. And that might be, I'll give a little explanation now, but maybe that's something to bring in at the end, because this could take us on a crazy tangent. So I think that the most basic standard here is, does it uphold the basic argument for intellectual property laws given in the Constitution? It's actually the clause that says why or how Congress can establish copyright laws and patent laws and trademark is one of only 2 places in the Constitution that gives a Congress shall do this because of this. It gives an explanation why. And they say that they can establish limited monopolies in order to promote the useful arts and sciences. So promote the progress of the useful arts and sciences. So I think that the baseline bad, and it gets worse, but the baseline bad is that things like the Copyright Term Extension Act stand in opposition to that. So then you've got, so Pro-IP put in place a system where the ICE, Immigrations and Customs Enforcement, can seize domain names domestically. And that's bad for a whole host of other reasons, some of which I'll get to when talking about SOPA and PIPA. And then if you still have questions, I'm happy to address them at the end, but I could go on this for a while. CDA, the CDA, again, it was mostly considered harmful at the time. It was also mostly overturned, thankfully. But I mention it because of two things. One, Section 230 of CDA established the safe harbor provision in general. So the DMCA builds on the CDA 230 safe harbor provision. The other thing is that when the CDA was passed in 1996, there were online protests that consisted of sites blacking themselves out, and it was a measurable percentage of the web at the time. And so these tactics that we've seen now, they've been, it was 17 years in between, give or take. But I guess it was the end of 95. So 16, 17 years in between. But they're not wholly unprecedented. It's just a new scale now that we're talking about this. The DMCA has also been subject to some activism. For one of the very first DMCA cases that came to court was about a series of memos. It was a collection of thousands of memos internal to a company called Diebold, which, among other things, makes voting machines. And after the 2000 election, they sent around a set of sort of frantic memos, some of them, saying that there were major problems with Diebold voting machines, and they might have been implicated in affecting the 2000 election. And these memos leaked, and a lot of people participated in this, hosting these memos on their own web space so that they could distribute them. And the tactic that Diebold at the time decided to use in order to take them down was to assert copyright over these memos. Our employees wrote these while they were on the clock, and so therefore they're works for hire, and so therefore we have a copyright in this, and so take it down. This was it wasn't the first example, not by a long shot, not by 300 years, but it was a very prominent example of copyright enforcement as a form of censorship. And so this is always something to think about when supporters of these bills say, well, sure, we like freedom of speech, but copyright infringement isn't free speech. In some cases, things that could be called copyright infringement absolutely are. And if SOPA were in place at the time that these memos had come out, it would have been much easier for these companies, for Diebold in particular, to go to their ISPs and just have them cut off. And so anyway, I'll get more to the problems with SOPA, but another clause in the DMCA, I mentioned that there were two that people talk about a lot. The other one is Section 1201, which talks about anti-circumvention. So not only are there the rules put forth in the DMCA, but you're not allowed to circumvent any technical measures that are designed to enforce these rules. And that can be encryption or DRM or any of these sorts of things. One prominent one was the DVD, which the DVD standard includes encryption. So you shouldn't be able to rip it and to re-encode it. But it turns out that it wasn't a very effective form of encryption. And so a 15-year-old in Norway broke it. And he wasn't the only one, he wasn't even the first one, but he was a popular one. And he broke it, according to him, in order to play DVDs on his Linux computer. A pretty standard usage. It's a sort of thing that absolutely would be fair use. but because he was circumventing the technical measures designed to protect the copyright, it went into a lawsuit that was dragged on for years and years. And so those anti-circumvention clauses, and I bring both of these up to say that anti-circumvention clauses and copyright enforcement tactics that can be used to silence any sort of speech raise red flags for anybody who's in this field. So, but supporters say that these are necessary, and they say that it won't violate your regular freedom of speech only if you're a pirate, and they say that there are these rogue sites all over the world that they can't access. Anyway, I'll address each of these one by one. So what's so bad about the Stop Online Piracy Act and the Protect IP Act? There's a lot, but I've broken it down into 4 main categories. One is technical problems with the bill. Until recently, both Protect IP and SOPA mimicked a clause in COICA, which was shelved last year, which was DNS filtering. And so the way that it was proposed that they would censor these websites that were engaged in copyright infringement would be to filter them at the DNS level, which is sort of like China does it. And actually, the MPAA, a representative of the MPAA said, we think this would work because, hey, it works in China. They don't know how bad that sounds. So there are a couple of problems with this. One is that it breaks DNSSEC, which is I imagine that this is a room that probably knows that, but just as a quick refresher, it's a security initiative to make your connection to a DNS server to verify it, basically. That's cutting out a lot of, but it's also ineffective because it wasn't blocking things at the IP level, just at the DNS level. And so if you know the IP address of the site that you're trying to get to, you could just enter it. And if you used a DNS server not in the United States, you could just go to the website. And if you had a list of IP addresses and domain names, even the ones that are blocked in the United States, and you told your computer to use that list first, then you wouldn't even notice a blip. So there are a host of technical problems. And it's not a surprise that pretty much everybody who has a technical background, including a lot of the major architects of the internet, came out against especially the technical provisions of these bills. So that's just the first step. The second step, and probably one of the most important, is that these bills would hurt freedom of speech. And it would do that in a number of ways. So let's go back to this technical problem of all these ways to circumvent SOPA and PIPA. How do they get around that? Well, they put in their own anti-circumvention clause. And this one actually goes one level further than the DMCA. So not only can you not say, guess what, the IP address of the Pirate Bay is, and then give 4 numbers and 3 periods, you can't link to a site that says that. And you can't link to a site that would distribute these, a browser add-on that goes around. And so DMCA already has sort of a 2-layer thing where you can't, not only can you not use the tools, you can't distribute the tools, now you can't link to the tools. So there's a number of ways that that this could this is problematic. Another thing about these anti-circumvention tools is that the State Department actually funds a lot of them for use in countries with, for use in China, for example. So one of the big ones that would be targeted by this is Tor. Tor, which is a system, it's the Onion router, and it's a system for basically, and again, this is rough strokes, but bouncing your connection off a number of places so that it's not clear to the site that you're connecting to or to anyone in between who's making the request. And so that sort of thing would just get right around the provisions. So that would have to be outlawed domestically. Even though these are the exact same tools that are being used by activists all around the world. So you'd have a system where the State Department could still be funding these tools that it would be illegal to use here. Other things is, other elements that affect the freedom of speech is that it would impose costs to the platform. So I mentioned a minute ago that YouTube gets an hour of videos per second. So if you were starting a new video site and you thought, in 5 years I could be getting an hour per second, you'd have to start with a legal team. And so, especially in this room, probably a lot of people know a lot of companies that started in a garage or in a dorm room, and with just a person with technical chops or with business chops. And now you have to add to that runway, you have to have a lawyer on retainer. So you'd have fewer of these platforms, and these platforms are being used by people all over the world. And I don't want to make too much of the Twitter revolution or the Facebook revolution, but platforms like, or movements like the various Arab Spring movements, and even things like Occupy, did absolutely use these platforms. And so if they no longer had access or free access or fast access to these sites, if they had to verify their identity in order to use a platform like Ustream, then there are absolutely freedom of speech implications. Another thing, another problem is that these are expensive to US companies. The supporters like to say that there is no cost to US companies because this is just targeting foreign rogue websites. I don't understand how you could read the bill and come to that conclusion, because not only was there DNS provisions, which of course American DNS servers and ISPs would have to keep up with and implement a system of blocking, but there are also search engine blocking provisions. So if a site got taken down under SOPA, you could no longer link to it in search results. So that's absolutely a cost that sites like Google and Yahoo and Bing would, I guess, would have to take on. And so it's, well, the end result, though, is that these are not effective. So if the first three reasons weren't enough, and they would have been enough for the EFF, we would have said these bills are a problem, but ultimately they're not effective, which I think changes the discussion. For technical reasons, because the IPs are still accessible, but more importantly because they miss the point. They miss the point because the problem isn't well defined. So the supporters talk about these rogue sites, these rogue foreign sites. They can't name them. And so the US Trade Representative in December, in support of these bills, came out with a list of 19 sites that demonstrate the need for SOPA and PIPA. So 19 sites is what this is about. Included on this list was a site called Mega Upload, which I don't know if, I've been following it. But Mega Upload was taken down by the FBI this week. Right after Blackout Day, we got news that one of these foreign rogue sites that's ungettable under current law is being taken down. Another element is that even by the film industry's own estimates, which are liable to be, the problem of domestic piracy by sites that are based internationally. So the only thing that SOPA and PIPA are designed to address amounts to less than $500 million a year. So $500 million is a lot of money, but it's about the gross of Alvin and the Chipmunks to the Squeakquel. So we're talking about a relatively small amount of money for a relatively small number of sites, and that's what we're going to use or that's the reason that we're going to give in order to impose all these other restrictions. So who opposes these bills? It really became sort of a who's who of anyone who has political positions. Nearly every major tech company or tech expert, with a handful of prominent examples, but really a handful, First Amendment lawyers and scholars came out in droves against the First Amendment aspects of this. And a lot of them were saying that these are plainly unconstitutional. If they pass and it comes to the court, these are going to be overruled. So it does, anyway. Political groups across the spectrum. So you had Move On coming out, you had Red State coming out. It was truly a non-partisan issue. Public interest groups, obviously the EFF, but there were a number of them, all came out against it. So I want to talk about the way that this took shape. And some of that requires a little bit of knowing how bills go through Congress, because the major activism points happened around waypoints on this bill's progress through the Senate and through the House. So the way it happens is a bill is proposed either in the Senate or the House, or sometimes the same bill in both. And then typically it's proposed in committee, and that committee holds a hearing. And there are different committees, and they hold hearings, or sometimes many hearings, to hear from experts about how these bills would affect their subject areas. And you can imagine that Congress has to pass a lot of laws about very complex things. It makes sense that they'd have these hearings. The Protect IP Act had 0 hearings. And the Stop Online Piracy Act had 1 hearing. And there were a number of tech companies that asked to participate in this hearing, asked to fly themselves out to Washington and go up on the stand in front of the Judiciary Committee, and they were roundly refused. It was 6 witnesses, is what they call them, 5 of whom had already come out in favor of the bills, and Google. And Google, this was not the first time, but and it won't be the last time in this activism campaign, was set up as sort of a piñata. So they were brought into this hearing really to be told why they were condoning and endorsing and facilitating piracy all over. You had a number of instances in this hearing where they would say, where one of the congressmen would say, well, if you try Googling for J. Edgar, which was a movie out at the time, all you see is results for how to pirate it. Plainly false. But this is so there was the one hearing, and this is what it looked like. And then after the hearing, these bills go to what's called markup, or they're amended, and then amendments are proposed, and they go to markup, and during markup they discuss the amendments, and it can either pass out of committee or not. So that's the whole civics lesson for now. But I'm going to talk about how the activism developed. So November 18th was the first and only hearing for the bill. And we had a little bit of notice, and a number of sites put together a project called American Censorship Day, which was a little bit, well, it ended up being a lot smaller scale than the Blackout Day, but at the time it was one of the bigger things like it that had ever happened. So a number of tech guys put together tools to automatically censor your website's logo. And a number of more high-profile groups got on board. And you have to understand that at the time it was pretty impressive that Tumblr censored their homepage. And Tumblr, the blogging platform, they've got a very high traffic website, and they put a call-in tool directly on the front page that said, hey, we oppose these bills, we think you should too. Call your congressman right now. And you'd enter your number and it'd call you. That generated over 80,000 phone calls that day. At one point, it was 3.1 calls per second. So it was a real melt the phones tactic. And by most measures, that should have worked. When you see that sort of public outcry, as a legislator, you have to imagine there's something wrong here. But Lamar Smith, the author, didn't budge. And he said, these aren't legitimate complaints. I'm not going to listen until someone can point to parts of the text, which had been done, where there are specific problems. So and a number of other sites. There were we run a tool. The EFF runs a tool on our page to send an email to your congressmen and senators, and we had 100,000 people take it that day. So we're a small organization in San Francisco. 100,000 people is a lot to go through our site. In the weeks after this, outrage over Lamar Smith's ignoring the way that this had happened, it really started to build up. And one of the things that happened that was really interesting is that more tech tools started to emerge. And so people ran a site that allowed you to, you could log in with Twitter or Facebook, and it would change your icon to something opposed to SOPA and PIPA. And this is real. That's what we like to call clicktivism. That doesn't really matter, but it does show that there is this public opinion coming out against it. Other things that we saw like that is people were building visualizations of who would come out in favor and how much money they were getting from the MPAA. And someone built a mobile app that would, some of these things, that would get your location and tell you if the representative in your current location opposed or supported SOPA, and would let you call them at that moment. So these things started to emerge. And importantly, they're building on previous tools. So a company called Mobile Commons, which uses a platform called Twilio for making phone calls, they powered most of these call-in campaigns. And so these activism tools had been prepared, and this was really the time that they got their chance to test it out and see how it works. Just one other quick example of the way that activism was developing was the GoDaddy domain transfer day. So GoDaddy was one of those prominent tech examples of a company that actually was supporting the bill. And there are important reasons why they might. One is there's immunity granted to the sites that to the service providers that undertake these actions against infringing sites. And actually, just as a quick side note, that immunity is one of the most dangerous provisions in the bill because even though there's supposed to be a court order system, if you're a service provider and you have a good faith belief that the people to whom you're providing a service are allowing infringement, then you can take their site offline or take action against them without any sort of liability. And so you can imagine, you don't even have to imagine. Monster Cable has put together a list. A major ad network site has put together a list called the M Group, and these are sites that they've published that they believe are these rogue sites. And Monster Cable included things like eBay and Costco. If the MPAA were to put together a list like this and put it into the hands of a company like GoDaddy or one of these ad networks or a search engine, these companies could reasonably have a good faith belief that, hey, we were told by these copyright holders that these sites are engaging in infringement. So we call that the vigilante provision. And GoDaddy liked the vigilante provision because it kept them not liable. GoDaddy tried to pull the same trick as Lamar Smith. They dug their heels in and said, no, we don't really see a problem with this. And then people really started transferring their domains away. And this was organized in large part through a site called Reddit. And tens of thousands of people, especially in the lead up to the big day, December 29th was the domain transfer day, actually pulled their domains off of GoDaddy into other sites. And actually a number of other sites were doing the the rescue marketing strategy where they said, hey, if you transfer to us, we'll donate $1 to one of these public interest groups. And so Namecheap is one such platform, and they got 50,000 domain transfers in one day. So this is really, it was really having an effect. And a couple of days before domain transfer day, GoDaddy changed their position. And then the Reddit community was not satisfied that they changed their position enough because they hadn't formally rescinded it from the House. And so they changed their position more. They said, we oppose this. We're telling the House we oppose this. And this is, I think, a real wake-up call to a lot of these legislators, that these people are actually, this is not just clicktivism. These people are taking their dollars somewhere else, and they're doing it by the tens of thousands. And so it was really, that was a really important moment in the campaign. Of course, it gets bigger. What's going on here? Oh, my computer's frozen. Yeah, the MPAA has the bat signal. Let's see. I don't know exactly which part's next. Otherwise, I'd just go for it. I don't want to start talking about it and have the wrong slide show up. Probably.
There you go.
So, okay. So then Blackout Day, of course. That was really the crystallized moment of what was happening with SOPA and PIPA. And this is, I think, what everyone saw. Major sites across the web either took themselves down entirely or very prominently put up an ad indicating that they were against these bills. Google had a petition. Generally, petitions are sort of lower in the ranks of effectiveness politically. But when you get 4.5 million signatures in one day, people start to realize that this is maybe important. Wikipedia had a tool to look up your congressman and call them right now. And they had millions and millions of Americans do this. By some estimates, 1.5% of the US looked up their representative on Blackout Day. And we're still trying to figure out how many calls there were, and it was enough that at one point Senate.gov went down. It was just it was an organic DDoS kind of thing, and it was the kind of traffic that I don't think they've seen for any issue before, concentrated in one day. And in terms of internet activism, it was certainly unprecedented. It was people coming together. And a lot of people like to, supporters of the bill who are still supporters of the bill, talk about these tactics as being dangerous, or that they were just done by uninformed people, or that Google has such a strong financial interest in this that they pushed it through.
The term childish.
Yeah. Well, my favorite response to this is Chris Dodd, and I'll pull a couple of quotes from him later. He's the president of the MPA right now, and a former senator, very recently former senator. And he said that he was the one who said these are dangerous gimmicks, and that it was organizations that had access to millions of people and no fact checker were pushing their political opinions down people's throats. This is said by a man who represents the companies that make every movie, own every radio station, every billboard, every television station in the country. So it's not that there wasn't a platform for this. It's that there wasn't a good public face on this bill at all. So this had a really profound effect. And the bills started to fall apart. And it was really, it happened very quickly. Blackout Day was last Wednesday. It was now a week ago. Yesterday, the Senate was supposed to hold a vote on Protect IP. So it was a short timeline, but by Friday, that vote had already been canceled. Over the course of Blackout Day, you had dozens of senators and congressmen, some of whom were co-sponsors of the bill, coming out against them. You had, I've heard reports from from staffers in these offices that said the phone just didn't stop ringing all day. And they had all of the lines lit up for the first time. The phone, yeah, in the house, the phone system did briefly crash. And even without the crashing, you had people where it would ring and ring and ring and ring because the mailboxes were full, kind of thing. So this is really a pretty, they were reacting to something real that was happening. And then just as a quick kind of post-mortem on the actual events, Senator Reid announced that he wouldn't require Democrats he wouldn't hold them to what's called the whip to vote a certain way on the bill. And then the Senate Minority Leader asked Reid not to go forward with the vote, and they pulled the vote. And Leahy and Smith have both said that they're shelving SOPA and PIPA for now. Because it's 2012 and it's an election year, that probably means that they're not coming back for at least another year. So what's next? Nothing immediately. There are people who are concerned. Yeah? So there are, I'll get to that in a minute because there's a number of ways that, a number of sort of scary things about that. So these are too politically toxic to pass in exactly this form, in exactly this, on this platform. They'll be back. As the history is there, these sorts of bills come back. So SOPA and PIPA are probably dead for now. The name is probably gone. No, they're not going to rehab the SOPA brand at this point. But we expect to see this sort of legislation come up again. And I'll address the international thing after, and it's in 3 slides, I think. So why did we see this sort of reaction to these bills? There's a lot of people who are in this space and saw the NDAA pass a few weeks ago. And there was, in certain circles, that's the National Defense Authorization Act, which is, if you don't know about it, I suggest you look it up. Because it was a really scary bill that dealt with indefinitely detaining US citizens. There are people who would say that is probably on the same tier or maybe even one tier up from freedom of speech online. I think that both are important, but it's interesting that went by pretty, relatively under the radar. There are people, people in this room, educated people who just didn't hear the name at all, which is different from what happened here. One reason is that it affected sort of immediately a very broad group of people. It wasn't specific to any kind of person. It's just people use the internet, and it turns out today that's most of them. And importantly, included in that group were technical people who could build the tools and could throw together a website explaining what was wrong with this, and could make videos in many cases, or infographics, and this sort of thing is important. And Tumblr as a platform was able to push this bill that was important to Tumblr because they had a billion-page view site that they could put a call tool on the top of. Another reason was that, and this goes back to the broadness, these bills were never, I say bipartisan, but it really was nonpartisan. Supporters of the bill like to say that these bills were some of the most nonpartisan bills that had been introduced. They had broad support on both sides of the aisle and broad opposition. And I think that seeing the opposition come together like this, seeing Move On and Red State, and the Heritage Foundation and Cato Institute, as well as the ACLU on the same side, seeing Darrell Issa and Nancy Pelosi, I don't know if you guys are Congress nerds, come out together, it's pretty unusual. And so that sort of thing was powerful. I left out an N here, I mean exchange. The other thing about these bills was there was so little public support. They didn't have a public face. And so it really was a flagrant example of an exchange of money for influence. And I think that particular issue really rankled a lot of people. Chris Dodd has two really great quotes. I'm sorry, I guess it's not that small. The quote was, "Those who count," oh, I have another typo in here. This is the one I typed right before because I wanted to bring this up. "Those who count on, quote, Hollywood for support need to understand that this industry is watching very carefully who's going to stand up for them when their job is at stake. Don't ask me to write a check for you when you think your job is at risk, and then don't pay any attention to me when my job is at stake." So you have the president of the trade group pretty publicly talking about bribing legislators. And that's...
That was on Fox News.
Yeah, that was, and he didn't realize this would be a problem. This was really, it was bringing to the fore these issues that this isn't uncommon. It's uncommon that this is public, and so, right, exactly, and right, yeah. So Lessig, of course, has been or was in the copyright reform world for a long time. And just moved on last year to the money and politics reform, because this is really at the root of these sorts of issues. So I think that was an important thing that got people really riled up. Another thing that he said that just, again, he didn't realize how bad it sounded, was he was a senator for a long time. And so he's seen a lot of political campaigns. And he said this one, in sort of his concession speech, which he gave to the New York Times, he said this one was unprecedented. This was like the Arab Spring. I don't think he thought through that analogy all the way. Because what does that make him in the MPAA? But it was really something spectacular. And so given those, cool. I think I forgot to end this slide, and so this is the last slide for now. Yeah, I didn't put an end slide tag because I wrote this one just before because I wanted to get this quote in. Anyway, I can finish up without it. So what does this say about I think there are two areas that I want to address real quickly that are affected by this. One is the future of copyright policy. And I think the truth is this generated a lot of enthusiasm, but I'm not sure it's enough. And I'm not sure that there's the political will among these people to turn it back. More importantly, I don't think, and the EFF doesn't think, that more legislation is the answer to a lot of these problems. I think that we'll see them get resolved when the trade groups realize that these are business problems that need business solutions, and that this piracy is a symptom of market failure. And once those get addressed in a business way, then you won't see as many of these bad laws being passed. That said, there are a lot of bad laws on the books, and hopefully this enthusiasm can be channeled towards maybe repealing or clarifying or reducing some of those. And there are some in the works. One is one that a lot of people have been talking about in the last few days has been the anti-counterfeiting trade agreement, which is could be the subject of a whole different talk. But it was a secretly negotiated agreement that between secret representatives of the U.S. and a number of other countries to impose international IP. I try not to use the phrase IP, but copyright and patent and counterfeit and trademark rules, and really to police the internet. And the other one that people are talking about now is PCIP, which is Protect Children from Internet Pornography, from Lamar Smith, and it's one of those ones where child porn is one of the four things that you can yell and get your bill passed. The other being terrorism, drug dealers, and piracy. So it didn't work with piracy. So they might try to take the same laws and just put them in place under protecting children from child pornographers.
Hold on. The MPAA claims copyright on child porn? When did that happen? They didn't even claim copyright on XXX.
Yeah.
And now they're claiming it on child porn?
So they're not. They wouldn't be passing this as a copyright provision. They would be passing this in order to implement the infrastructure for censorship. To say, well, we can take this sort of thing out at the DNS level, and then the bill that adds SOPA to it can be 2 lines long. It can say, Section 103C is amended to read and copyright infringement. And so there's a lot of reasons to be concerned, but we're moving on. And one other important question is, what does this mean for internet activism in general? And I think that seeing this campaign is really going to invigorate a lot of activists in other areas. One direct example is around the world. So people dealing with the same sorts of laws in their home countries. There's been a lot of information revealing that the U.S. is pressuring other governments to pass these laws, including memos came out between the U.S. and the Spanish government. They came out in the WikiLeaks cables, incidentally, saying that you need to pass stronger copyright laws or face trade restrictions. So Ley Cinde, as it's called, the Spanish law, has been rebranded by activists as Spanish SOPA. And there's an Irish law that's similarly troubling, and it's now being called Irish SOPA. And so that's one quick way that this sort of activism can be applied. But then also, these tools are in place. And so things like this company Mobile Commons, which placed probably 500,000 calls, they are out there, and their widgets are easy to install. And so it took a tech issue to get the tech people to say there's got to be a solution for this and find it. But hopefully that can be exported to other areas. So I did want to leave some time for questions, and I do have a thank you slide, but unfortunately you're not going to be able to see it. But yeah, that was what I wanted to say before questions. I know that there's probably a lot here, so I'll just get to it. Thank you very much, and yeah, I'll take questions now.
It seemed like with SOPA, the goal of SOPA was really to identify websites trafficking in illicit content and somehow prevent access to them. A lot of your complaints on here are complaints about how that was implemented, technical difficulties, how it would be ineffective, how it would be expensive for companies. Does EFF generally agree with the broader spirit of the law of trying to cut off access to web websites?
I would say no. That sort of technique hasn't been, regardless of the technical implementation, hasn't been justified at this point. That there haven't been any peer-reviewed studies about the effect of piracy, and that's important because we see the movie industry's numbers go up and up, and so the fact that they're complaining about this problem, they really need to identify precise and measure what the problem is. But then the other thing is that every industry in the world deals with its own form of piracy, and you don't have to sympathize with it to know that legislative reforms aren't the way to address it. So Walmart, for example, they get shoplifted from. That's a fact, and they have policies in place. And the act of shoplifting itself is illegal, but they don't go to Congress and say, we think that as a matter of law, there should be cops shaking down teenage boys who look like they might be shoplifters. They address it in-house, and they address it as a business problem. And so,
They call the cops to arrest the shoplifter, don't they?
well, yeah, and there
So
are.
they do use the state.
They don't fight for new laws, and there are. It's not that there aren't laws in place to address these things, and the FBI takedown of Mega Upload is one example of, the laws are in place. It's not, but at this point, the idea that we will be able to control that type of behavior hasn't been demonstrated. And so regardless of your stance on piracy or unauthorized downloading, or there are people who are on both extremes. Some people who say that there should be no sort of copyright at all, or that it's outmoded. Taking as a given that the problem that the content groups have identified and called piracy is a problem, so granting that, the most effective way to solve that looks to us to be innovating in the business sector.
Are you familiar with how Mega Upload came under U.S. jurisdiction?
Yeah, it's a long indictment, and it's not certain that all the things are going to stand up. But
well, the big thing the U.S. said they have on Mega Upload now was that they actually used some server space in Virginia to store their material. Everything else is based in Hong Kong or New Zealand. As long as they did that, they were fine. U.S. could not touch them. They slipped up, stored a little bit in Virginia. That's how they got caught. We have other websites that maybe do keep all their stuff in Hong Kong and New Zealand, and they don't have to worry at all about prosecution. I'm not a big fan of getting censored and losing my freedom of speech on the internet, but I do feel kind of bad for these companies that are trying to produce material and make a profit off of that, whether that's movies and music, or even just making purses and having those get counterfeited too. Is there a way that EFF sees that could somehow effectively combat some of the piracy at least and still be acceptable to speech advocates?
I think that, again, arguing for an evidence-based policy here, to take a similar example, there was a period of time where BitTorrent was the most traffic that was being transmitted through through the series of tubes. And I think that if you asked the movie industry then, will that ever change? Their answer would have been, yeah, if we pass laws to make it change. We have to either outlaw BitTorrent, or we have to go after these pirates one by one, which in some cases they did. But what actually made, that's not the case anymore. It's not the biggest source of traffic. The biggest source of traffic is, most evenings, Netflix. Netflix came on and gave a simple solution that at an affordable price that makes the studios money and displace this problem. And if they were allowed to have, if these companies were allowed to innovate in more spaces like that, I think that you'd see more of these problems displaced.
Well, there's another difference, though. If Walmart calls the cops on somebody who wasn't stealing anything, they have liability.
Right.
Whereas if, I can call in a thing to Google and say it's copyright infringement, and they're sort of obligated to deal with it, even if it's something that's, that you would clearly recognize as not mine. So you can there's no liability for making false accusations. But where I was going to go was, if I'm pushing the law and you say, oh, it doesn't work because it's at the wrong level, I can still use IP addresses. My response is, cool, IP filtering. I know how to do that. There's that Cisco company, and they're really good at IP filtering. Why did they do that?
I think this may sound a little cynical, but it appears from the bill that they didn't consult with any experts.
So they don't have to consult with experts. The first time you tell them the weakness, you just say, cool, thank you. What's this called? IP.
This is like the guy from Embry last quarter. He, you guys were talking at cross purposes to each other. He one of his comments to you guys was, "Hey, stop blaming Microsoft." And it's like, and Dave Shurton was back here going, "Hey, the solution's cryptography," and he said, "No, we don't need cryptography."
I also think that some of it is a mindset issue, and it's that what they really want to do, what these movie studios understand, is we are the good guys and the Pirate Bay is the bad guys. Mm-hmm. And so they were told, they talked to somebody and they said, okay, how do we block the Pirate Bay? And the tech person rightly said, oh, you want to block access to the piratebay.org? Well, you do that at DNS level. And
No, you do it at IP level.
well, but that's not
Even
the
the Chinese are smart
piratebay.org.
enough to figure that out, to bring back.
These guys don't understand technology.
Well,
They're not interested.
but they don't have to. All they have to do is listen to the opposition and say, oh, so this doesn't work because. Okay. Thank you.
Yeah. Well, so I'm not sure why they didn't go with.
That's not the way policy discussions go. I mean, we're right now having one of these things going on. Some people are commenting that when you've got people trying to put policy forward, they have a certain approach to doing it. And it doesn't happen to include the kind of constructive response you're talking about.
Right.
It
I
just
would have
not,
called
just
destructive
doesn't work that way.
I think, and just to add on to that for a second, in the like concession speech interview to the New York Times, Chris Dodd said, "All right, we hear you. We want to sit down and talk to these internet companies." And people on the web said, "Wait, this wasn't about companies. This is about all of us. It's about all the users." And so having a meeting, and he proposed the White House. He said, let's have, let's get the top guy from Google into a room with the top guy from the studios, and they'll work something out. And I think that, that was real. That's what he proposed. And so I think, yeah, it reflects that they're thinking on the wrong level, not like, let's figure out how to make this the best policy we can, even if their goals are wrong.
Right. We don't have enough lobbyists.
Yeah?
Yep. There's I can't tell whether I'm just naive and this is the way Congress works. But no, my background is engineering, okay? And if somebody tells me why my thing is not going to work, I say thank you.
And that's
And
probably...
that was back, there was the white paper on the DNS stuff back in May.
Yeah.
Is Congress just immune to technology?
I think you've identified one of the reasons why engineers have more than 9% approval rating. It's not. You had in the markup session, you had congressman after congressman say, "I don't understand this, but we haven't heard otherwise." And I was sitting in my office in San Francisco watching the hearing, pointing at these, the EFF organized a letter from 83 of the architects of the internet. We had, Vint Cerf and Paul Vixie, and and all the way down.
Hey, and
It was, but it just doesn't get through on some level. If you're not, I guess not. I mean,
Staffers are proto-congressmen. They don't actually
Right.
have technical skill.
Yeah, not gonna get through.
yeah.
Let me flip it. If I'm MCIA or whatever and want to block much of this counterfeiting, couldn't I go easily without the government to Visa and the other credit card dealers and say, okay, under the table, we'll tell you the sites, or publish it, that you will not process credit cards for. We don't need the government, and therefore 90% of that revenue will not occur. Those sites will not get money, and it's out. The government says, wouldn't that do? It won't.
they're not making money.
It actually,
They're not,
I'll bet most of the.
actually, the economics of file sharing sites are sufficient. The economics of file sharing sites, specifically Mega Upload, are such that they can live on advertising. They don't have to have payments from customers.
What the studios make, and the big issue here is business model. That the studios know how to ship something physically and make a certain amount of number from it. When it's a digital file, they're wondering what to do. And what Google showed us is what you could make your money off of is not the file, but the eyeballs.
Yeah.
Apple and AOL before that. And so there's a real what do we do now question that I'm really curious how you guys are looking at that.
Yeah. So I think to address the specifics of that question before getting into the generals, there are free speech problems with that too, and we don't want to see But it was brought up in the hearings because there was a representative from MasterCard there, as sort of the follow the money approach, which was, or, you know, I don't know what your politics are, but it was effective against WikiLeaks, at least for a while. And it really did push that organization to the brink of collapse, in addition to all sorts of other things. There are problems with the way it was implemented there, but it
was effective,
right.
but you're saying that it's not raw money, it's advertising.
Well,
If you wanted to
and you
deal
can
with
raw
these
money.
small sites.
Adver-
I mean, it's not
They're not small
buying
sites.
the movies with a credit
They're
card.
not small sites.
No, but I know it's not customer money. It's advertiser money that's a problem. And you do right. There's a list called Group M, which some of the major advertising sites have agreed to that they will not advertise on those sites, and it sort of works. I mean, I don't want to get too philosophical here, but it might work if your actual goal is to reduce the unauthorized downloading. If your goal is to maintain control of communications channels, because you have for 50 years, then it's less effective in that goal. And so I don't know if that's the MPA's goal, but sometimes it looks like it.
The goal being to identify people who are profiting off of your work becomes the only litmus test they can look at, or what can they use to somehow feel
again,
protected?
I mean, Mega Upload was one of the top 20 sites on the internet, and it was it cleared. I think the number was last year $110 million, which it's a lot of money, but it's not to them, and so that they should be. It's not about that money. It's about maintaining the control. But yeah.
I think control is control over your intellectual property, not control over the media by which it's transmitted one way or the other. The thing that you hit on and that I think we're maybe kind of all missing here is this is a business solution.
Yeah.
Okay, so is there any effort that you're aware of to address this as a business issue and come up with a business solution?
Well, so there are efforts, and then the efforts are cut off at the knee by the same companies that once they get successful enough. So you have things like Hulu. Hulu it's a video platform that has content from the major studios, and it was picking up, and it's a flat fee, and you can get a lot of stuff free, and there's advertising, and people like it, and it works, and people are willing to sit through the ads and willing to pay for this stuff. But then some studio executive got a demo of Hulu working on Google TV, and they said, wait, you can watch this on a TV? No, this is a computer solution. They don't realize that a screen's a screen. And so they're blocking it. They block a lot of content if you're watching it with a Google TV. Regardless of, you can hook your laptop up with a cable and watch it. But if you're accessing it through Google TV, you can't. And so they must know on some level, you can compete with free. You provide a good service. And there are efforts there. But then those efforts are being handicapped by executive, right? Yeah.
The video game industry shows a wonderful ability to adopt business models to technical reality. It used to be that video games were copied left and right, and copy protection was broken almost as soon as the game was released, et cetera, et cetera. Now they don't make their money by selling the games. They make their money by selling in-world things and other add-ons.
Yeah, and there are a number of industries that have done this. I think one of the ones that won't get mentioned in public very often is there's a certain class of videos that are copied and the ownership is unclear on the internet all the time. And that industry has figured out how to make money, and they make more money now than ever, even though they lost control of the copy. And yeah, it's possible. There are examples of this. And then you also have cases where, like, I don't know if anyone has played the video game Minecraft, which came out last year and was just like a smash sensation. And it was developed by a small developer. It was mostly one guy, but now it's 4 or 5 of them. And there's no copy protection at all. And they sell it, and they know that the more people are playing this, as long as they make it easy to buy it, the more people will buy it. And it doesn't cost them anything to make copies for people to play it. So they do this, and they've sold millions, and they make money every time they sell one. And every time someone plays it and goes, wow, this is great, where's this from? They're that much more likely to buy it. And you don't see that effort on an institutional level at all from the major companies.
Well, you did see, it was announced a couple of weeks ago, Megabox. They were going to have free downloads and pay content providers because they'd figured out how to extract money from downloaders via various means, premium downloads and other things.
That was Mega Upload.
It was the same people.
Yes.
But because they were hungry for content, so they said, we make money off of people downloading. We need content. We will pay people to produce content for us. Now, is a penny a download better deal than you get from iTunes? No, but if you get that penny from more people, sure it is, because the customer is paying, quote, nothing. So of course I'm going to download. No, I'm not going to pay 99 cents.
Are there any? Oh, sorry.
I should point out to you, it turns out there's a guy who's actually a Stanford graduate, a PhD, but not from the CS department.
Nobody's perfect.
He's been hired by actually a consortium of movie studios to do research. This is one of their topics. And he told me a very interesting story. He tried to open up a technical lab down in Southern California. And he convinced them he would never be able to hire anybody to come down. He had to open up the lab here
yes.
in Palo Alto, in Silicon Valley. By the way, he's hiring, if any of you want. And, the motion picture industry has a whole slew of problems, of which this is only really one. But, we as a country brought this on ourselves. We spent our first 100 years of our existence flagrantly violating everybody else's copyright. This is only coming back to haunt us. And, China tried to get away with it, and we said, no, don't do it. And they bowed under our pressure. But I've actually dealt with some of the studios like Disney pre-web. And their comment about us being kind of childish as a group, there's some claim to that. Now, admittedly, if you do something like a mashup, which may be complete, total data ripoff, I kind of snap. But for lesser things, some people would have called that in the past etiquette or netiquette, as an example. I actually got stills from the movie Tron right after the movie Tron came out. And I said, look, I'm just doing this for a paper, it's purely for research purposes, this and that. And they very gladly, all I need to do is sign this little letter saying it's not for making profit. And they're actually kind of amenable. I'm not trying to defend them.
No, I believe it, and there are smart people there. These are big companies, and they've been powerful for a long time. I don't doubt that there are smart people there, and probably increasingly, I hope, smart people who understand the situation here. And I think that that's the other thing about the business solution is it's sort of inevitable. I think that they either figure it out or they get figured out.
Well, they don't want to change their model. They've done this for decades. So
From our point of view.
Yeah.
You want to continue to do it that way.
Yeah. Well, I think that, hopefully they realize that, I think there's, I don't like to put it in these terms, but there's even more money to be made if they go after it in a business way, and they really could. They've got the best distribution channel ever invented, and they don't have to pay for the distribution anymore. And if they're gonna, they have to take advantage of it. You have I mean, just as like a one point of reference, I'm sure most of you, or many of you, have heard this quote. But in the 80s, there was this the Betamax case over whether VCRs should be made illegal. They had just been developed, and Jack Valenti, the president of the MPAA, who is Chris Dodd's old job, he got up before the House of Representatives and said, "I say to you, the VCR is to the American film industry and the American people as the Boston Strangler is to the woman at home alone." And that was their position. This technology will ruin us. We have to control it. And now, home video, which didn't exist at the time, in 1982 there was no such thing as home video, is 70% of the revenues of most movies that come out today. I think that I'm not saying that they have to get smaller, that they have to just realize this is a great distribution opportunity. And they can try to control it, and they've tried to control it every time there's been a new technology introduced, or they can figure out what the best way to address it is. And I think that if they don't figure it out, someone else will.
Experiment?
Exactly.
Do you want to talk about that?
So he's a comedian, and he gives shows, and he did 2 shows in New York, and regular shows, but he filmed it also, and he hired a crew to come and film it, and then he actually also does film editing, so he edited it himself. So he actually made money from doing the shows live. He spent about $250,000 producing this high quality video, and then he sold it on his website just through him. $5, you get it DRM free, you can download it, you can watch it on any device you want, super easy distribution. He gave a personal plea, hey, if you like this is how you pay for it, and I'd appreciate it if you get it from me rather than a torrent network. Within 10 days, he had made over $1 million. And this is a guy, and he cleared over $1 million. And so that works, and he didn't have to pay the distribution channels to get into the video stores or into theaters. He did it himself, and he made a lot of money for himself. And I think that we'll see more of that. And I think a lot of people, I haven't seen, you've seen similar things. Obviously the Radiohead sold their album for what you want, and there's a musician named Jonathan Colton who is really great and gives all his music away free under Creative Commons license, and makes his living that way. There have been a number of success stories. I'm interested to see the next time HBO is trying to negotiate a comedy special. Because not only did he already make $1 million, more than he would have made, he owns the rights to this forever. And so he can still, in 10 years when people see it and enjoy it, they can go, oh yeah, I'd like to get that and buy it from him. That's another $5 in his pocket. Or maybe it's $2.50 then, maybe it's $1 then, because he's still making money for every sale. And so this is new economics, and they can, and it's their, they've got the content. It's their opportunity to take advantage of it.
By the way, it reminds me of Top parties. It's not quite the same, but basically it was a similar change from the standard model and an alternative model, and some people made money with it.
Yeah, didn't take over, but
yeah.
Okay, let's close it off, and then we can have all the cool stuff for people who showed up.
All right. So thank you, and thank you to the people online.
Yeah.
For more, please visit us at stanford.edu.